God is dawn. Like and subscribe. Comment some night. Loving this light. Here's God is dawn. God is dawn. God is dawn.
Peace, world, peace. Welcome or welcome back. I am Goddess Dawn. Yeah, that's right. Yeah, it's Sunday, July 11, 2021, and I'm back with an R. Kelly update. I'm actually here with beautiful Spirit. Yes, welcome back, sis.
Yes, welcome. We back again.
We back again. We actually just came off of a live, our Saturday night live. So if you missed that action, go into the archives and check it out. It is a pack full of fun and entertainment and information. So, but other than that, yeah, somebody was in the chat. I forgot who that was in the chat who told us, who asked us if we had heard about the new motion. So, but yeah, to my surprise, I had forgot all about it. I meant to check during the live. So my bad to anybody who was in that live waiting for me to do that. So yeah, there is a new motion, or new filing by the government, a motion referred to also as a memorandum of law. Its purpose is to protect the identity of certain victim witnesses. And I'm going to read from the motion, but not all of the motion. Let me pull it up on the screen. So it's a legit filing here. Is this dated? Yeah. Dated today, Saturday, July 10th. So it says it's a memorandum of law in support of the government's motion in Lamine to protect the identities of certain victim witnesses. So this particular motion is for the purpose of protecting the victim witnesses. In the preliminary statement, they break down what it's all about. And I'm just going to read some of it so we can have a clear understanding of what's happening here. So it's confirming that the trial in this matter is currently scheduled to commence on August 9th. And the jury selection does start on August 9th. So I don't know if that's why they're using that date, because we do know Judge Donnelly had pushed the opening statements to the 18th. But with that said, we'll go on. It says this motion in Lamine seeks to protect the identities of certain charged victims referred to as Jane Doe number 2, Jane Doe number 3, and Jane Doe number 5 in the third superseding indictment, hereinafter referred to as the victim witnesses, that are expected to provide and or will be the subject of sensitive and personal testimony concerning illegal sexual abuse, sexual contact, and other acts committed by the defendant at trial. I'm going to go ahead and read the footnote that goes with it. Says the government intends to file a motion to admit other acts of evidence as direct evidence of the charged racketeering offense and as evidence admissible under Rules 404B and 413 of the Federal Rules of Evidence. In connection with that motion, the government will also request that certain victim witnesses of the other acts evidence be permitted to testify using pseudonyms or their first names only. So that's the really bottom line of what they want. They want to be able to use pseudonyms or first name only to protect these victim witnesses, which is good because they do need the protection, as we know.
Yeah, yes, they do.
And they break it down specifically here. The government moves to the court to, number 1, permit the victim witnesses to testify using a pseudonym or their first name only. 2, limit references to each of the victim witnesses in open court to their pseudonyms or first names only. And number 3, prevent public disclosure via cross-examination or otherwise of victim witnesses' respective addresses, names of family members, or exact place of employment, if any. So basically, it's all about their protection. They're asking for the pseudonym to be used while they're on the stand, for the pseudonym or first name to be used in open court, as well as to prevent via cross-examination any information aside from their name, like their address and name of the family members or place of employment, to be disclosed.
Okay.
So the reasons are set below here. They say for the reasons set below, the court should grant the government's motion. So then they break down the reasons. They have a background here is number one, the charged conduct. And they refer back to the March 12, 2020 grand jury in the Eastern District of New York, which returned a 9-count third superseding indictment charging the defendant with racketeering and alleging 14 racketeering acts, including bribery, sexual exploitation of a child, kidnapping, transportation of minors and other individuals for the purpose of engaging in illegal sexual activity, illegal coercion and enticement of individuals, and forced labor, as well as violations of the Mann Act related to the transportation of individuals, including a minor, for the purpose of engaging in illegal sexual activity and illegal coercion and enticement of individuals, including a minor, in violation of 18 U.S.C. 2421, 2422A and B, and 2423A. Okay, because these things can be Googled, too.
You can research, look it up.
Yeah, look it up. All right. So they also go on to describe the charged victim witnesses. It says the government anticipates that the charged victims, Jane Doe 2, Jane Doe number 3, and Jane Doe number 5, will be called as witnesses at trial and will also be the subject of testimony and other evidence elicited at trial. Now they call them the charged victims. So yeah. I'm not positive what that means. If you know, leave it for me in the comments. If you have some legal expertise and you know what that terminology means, I'm going to find out by my own attorney, but he might try to send me an invoice. So put it in the comments. Give me some free advice here. So they go on to break down the Jane Does. And I was hesitant to read the details because they get a bit graphic with regard to the charges. But if we're going to be dealing with this trial and if the information is public, then we got to go there, right? Because we got a lot to cover that's coming up.
Because it is public what we have right now. So
definitely is public. All right. So we'll go with what we're not going to do, though, is we're not going to sit here and pick on which victim is which Jane Doe and whatnot. We're just going to leave it at the Jane Doe number 2, 3, and 5, which they have presented here. So with regard to Jane Doe number 2, it says the indictment charges the defendant with racketeering, including predicate racketeering acts involving Jane Doe number 2, an individual whose identity is known to the government as the defendant. The Jane Doe number 2 is expected to testify that she met the defendant in or about 1999 in Chicago when she was 16 years old, after a member of the enterprise approached her at a fast food restaurant and informed her that the defendant wished to speak with her. Thereafter, while Jane Doe 2 was a minor under the age of 18, the defendant engaged in sexual conduct with Jane Doe number 2 and on multiple occasions filmed Jane Doe number 2 having sexual intercourse with the defendant, thereby producing child pornography.
Wow.
Jane Doe number 3. It describes the same introduction here and says she's an individual whose identity is known to the government and the defendant. These are not secret people here. The court knows who they are. It's just that we, the public, should not be discussing these people because, we'll read it here. And it says Jane Doe 3 is expected to testify that she met Kelly in 2003 at a mall outside of the state of Illinois when she was in her early 20s and working as a radio station intern. The defendant thereafter invited Jane Doe number 3 to travel to Chicago, Illinois, purportedly to conduct an interview of him in connection with her employment at the time. Following her arrival in Chicago, Jane Doe number 3 was directed to a recording studio. Once there, she was escorted into a room within the studio by one of the defendant's associates who also took and searched her suitcase. Later, while in the room, another associate made a copy of Jane Doe number 3's driver's license, directed her to sign what she believed to be a non-disclosure agreement, and advised her not to talk to anyone and to keep her head down. Jane Doe number 3 ultimately spent approximately 3 days in the room, which was locked without sustenance. After a member of the enterprise eventually provided her with food and drink, she became tired and dizzy. So, and we know without sustenance, but means without food and drink, basically.
Yeah.
3 days.
Starved.
What'd you say?
I said she was starved.
Oh, yeah. Okay. It says she woke up sometime thereafter and saw that the defendant was with her in the room and that her underwear had been removed without her knowledge or consent, which in combination with other circumstances made it apparent that the defendant had sexually abused her while she was unconscious. And then lastly, Jane Doe number 5. I know this is hard to swallow. The indictment charges again the defendant with racketeering, including predicate racketeering acts involving Jane Doe number 5. The government and defendant know this Jane Doe. It also says here in parentheses, he is also charged with substantive Mann Act violations, including Jane Doe number 5. Jane Doe number 5 is expected to testify that she met the defendant in or around 2015 in Florida. And we know Mann Act is the traveling for the purpose of sex. Okay. But yeah, it says Jane Doe number 5 is expected to testify that she met the defendant in or about 2015 in Florida when she was 17 years old. After a member of the enterprise approached her at a concert and gave her the defendant's telephone number. Thereafter, while Jane Doe number 5 was a minor under the age of 18 and in violation of applicable state law, the defendant engaged in a sexual relationship with the Jane Doe number 5 and on multiple occasions filmed them engaging in sexual intercourse, thereby producing child pornography. As a result of the defendant's actions, Jane Doe number 5 contracted an incurable sexually transmitted disease at the age of 17. In addition, the defendant used physical force, threats of physical force, physical restraint, and threats of physical restraint and other means of psychological coercion to cause Jane Doe number 5 to engage in sexual activity, not just with the defendant, to which Jane Doe number 5 consented, it says in parentheses, but also to sexual activity with many other women and a man.
Wow.
The sexual activity with the others was always at the defendant's direction and in the defendant's presence and often filmed for the defendant's use. So they've laid out everything. And so now their argument follows and they go on to basically let the court know what they want from them.
And why?
And again, they want, number one, them to permit the victim witnesses to testify using first names only or pseudonyms, to limit each of the victim witnesses in open court to first names and pseudonyms, or prevent public disclosure via cross-examination, as was mentioned previously. Right. And it says that, as discussed below, these measures are necessary to protect the victim witnesses from potential harassment from the media and others, undue embarrassment, and other adverse consequences. They say that there is a legal standard, and they lay that out also. The legal standard pretty much cites a bunch of case law and precedent cases to support their argument. Okay, so there's a couple of cases mentioned here, and it says in the trial context, courts have found that potential for reprisals, humiliation, or annoyance are sufficient to justify non-disclosure of personal identifying information by a witness. And the information continues as far as precedents and case law is listed down here. Let me just say something.
You know what I just thought about? When they file the motions, they have to back up what they're saying. Like, you're asking for this, and this is why, and then here's the proof. That means they done provided those videos to the judge.
Oh yeah, those videos have been submitted to the court for sure, okay. And to the defense. Yeah. So, okay, this goes on. to state more case law here, and then even the Second Circuit Court upheld some things that they cited. It says, where the government seeks to limit disclosure of witnesses identifying information in court, the government must articulate a need for withholding the identifiers, such as fear of reprisal, humiliation, or annoyance to witness. Once the government identifies a need to protect the witness's full identity, the defendant must demonstrate a particularized need for the information, which the court weighs against the harm to the witness. So if they're going to request the victim's or victim witness information, it has to be a particularized need for it. It says more case law is cited. There's a lot of case law. Look, the government doesn't play when it comes to showing proof of why things are and what they need. Let's see. So let's see.
It's terrible about what he did, but I'm glad it's he had it on videotape. He can have evidence.
Right.
Showing himself committing these acts.
Right. That's all, in my opinion, they needed. But this goes on to describe that at certain sentencings of sex traffickers, courts in the district have permitted victims to give in court victim impact statements using only their first name or the name Jane Doe. So they're really laying out all the reasons, as well as in all the circumstances, that they need to be using the pseudonyms or first name only. And to mention the fact that the victims give in court victim impact statements, I'm guessing that's most likely going to take place in this trial.
Yeah.
They want them to use nicknames, first names, or pseudonyms. And then at the final analysis of this, they just go on to reiterate the fact that the victim witness is under a lot of stress and pressure. And I'll just read it. It says the limited protections required for victim witnesses' personal identifiers are reasonable, necessary, and appropriate to protect their safety and well-being, avoid harassment of the victim witnesses by the press and others, and prevent undue embarrassment and other adverse consequences, such as retaliation by the defendant's supporters. Yeah. Supporters. Need for relocation or loss of employment. The victim witnesses are expected to testify in illicit detail or be the subject of highly sensitive and personal testimony concerning their medical history and illegal sexual abuse by the defendant, some of which occurred while most of the victim witnesses were under the age of 18. It says, since the defendant's arrest, the case has garnered significant attention from local, national, and international media sources, which can only be expected to increase during trial. And we know that's going to happen. It says the defendant's arrest and indictment received widespread coverage in the media, and the case has continued to receive significant attention given the defendant's career as a well-known musician and the nature of the charges. And they reference in the footnote for this, C. R. Kelly indicted on federal kidnapping. They basically cite a bunch of articles and news links. Let me make sure I didn't miss nobody here, because sometimes people show up in these things and you be like, what?
I'm glad that the government, the prosecutors are trying to keep these survivors safe and everything to the best of their ability, because they need it.
Right.
Because the supporter is dangerous.
Yeah, they cite a bunch of articles. I'm actually going to have to look some of these articles up. So, of course, they're referencing, have we even gotten to that part yet? I don't think so. Okay, so this goes on to say the news coverage has not only centered on the defendant, but also has focused on the victims, attempting in certain instances to identify unnamed victims in the indictment through various channels. There's a footnote for that. Let me see the footnote. Okay, no, there's nobody's name there.
Okay.
Okay. So it says, in addition to the attention that the case has received from the press, the case has likewise garnered widespread attention and discussion via multiple social media platforms such as Facebook, Instagram, YouTube, and Twitter. And we know who they're talking about for YouTube, right?
Yeah.
This attention has not only consisted of discussions regarding the case generally, but has included attempts by members of the public to determine identities of the Jane Does named in the indictment and other potential witnesses, as well as online campaigns aimed at individuals presumed to be connected to the trial. Okay, there's a footnote. Let me look and see here real quick. Okay, so they reference Surviving Lies, which was what he tried to post in response to Surviving R. Kelly, and I remember that. And that's what one of them got shamed. I remember that now. Okay, let me see what else. It says, moreover, as the court is aware, the government has arrested and charged multiple individuals in connection with the interference with this case, arising from conduct including arson, attempted bribery, and harassment aimed at witnesses in this case. They go on to say, see United States versus Russell, United States versus Arline, and United States versus Williams. Wow. So the fact that they were arrested and charged in interfering with this case, are they also a part of the case? Are they going to be attached to it at some point, specific, directly?
I believe so.
Yeah. Now, the two listed, Arline and Williams, they pled out. And usually when you plead in exchange for something, and that would be information or testimony. So yeah, I wouldn't be surprised if they testify.
And it has to be proven what you offering them too with that plea. What you gonna give us? And they go check it out to see if it's signed, check, and delivered. Yeah.
They make sure it's worth it, definitely. So it goes on to say, under these circumstances, maintaining the anonymity of the victim witnesses is particularly appropriate. They say significantly, despite the case's publicity, two of the victim witnesses, Jane Doe number 2 and Jane Doe number 3, have not spoken publicly about their experiences and instead have maintained their anonymity. I always have a problem with that word, anonymity, with respect to the allegations against the defendant. While Jane Doe number 5 has spoken publicly about some of her experiences with the defendant, her anticipated testimony at trial will be more fulsome than her prior public disclosures and will include sensitive information that has not been previously publicly revealed. So we're going to get some stuff we ain't never heard, is what they're trying to tell us. It says publicly revealing the victim witnesses' identities would cause needless anxiety and social stigma, which concerns are further heightened by the defendant's notoriety and the long memory of the internet. Because the internet wins every time. It don't forget.
Yep. Once it hit the internet, it can be retrieved, baby.
Yep. So they're basically wanting them to, instead of requiring the victim witnesses to provide their identifying information in open court, because it would only serve to harass, embarrass, and to humiliate or annoy the victims. They just want them to be really referred to as the pseudonym or the nickname or the first name. It says, indeed, requiring victims of sex crimes to provide their names in public would chill their willingness to testify for fear of having personal histories publicized and the embarrassment and humiliation that such publicity could cause them as they rebuild their lives. It could be problematic, for people to show up and do what they're supposed to do if they feel and at the end of the day, they're going to be scrutinized, dragged through the mud, and everything else.
Yeah.
In addition, ruling requiring the victim witnesses to disclose their full identities publicly would cause other victims, including minor victims, to avoid seeking help from law enforcement because of fear that coming forward could subject them to further harassment and embarrassment, as well as retaliation by a defendant's supporter. So they're speaking in general, because they say a defendant supporters, that this could affect a whole world of future or current victims or future victims from coming forward. This case is historical, and this case itself will be setting precedent. And they're basically trying to just let the court know that it's so important that we protect these victim witnesses for the sake of, future victim witnesses.
Yeah. I agree.
Can't be mad at that.
No.
Yeah, because, they can't stress enough that there could be retaliation by defendant supporters. Because as we see in this particular case, those supporters don't mess around when it comes to sticking up for this man, and in the wake of that, or in the midst of that, tearing down and dragging down a victim or alleged victim.
Yeah. Like they stop at nothing. And even with the one female saying that, oh yeah, it's about time I gotta start dragging her again and all that. Like, come on now. These people.
Yeah. So, they go on to say in this motion that this is a well-grounded need to limit fully identifying these victim witnesses publicly. And by doing so, the defendant is not going to be able to articulate any particularized need for disclosure of these victim witnesses' identity in open court. It says counsel for the defendant is currently aware of the identity of the charged Jane Does, which will be confirmed by the government prior to trial, and has been or will be provided with any discoverable statements for the victim witnesses in the government's possession. And let me see, there's a footnote for that. That footnote says the jury will also be informed of the victim witnesses' full names. During the testimony, the victim witnesses will confirm their true names through photographs. I don't know why my voice keeps cracking. Through photographs depicting their full names underneath, which will be admitted into evidence and shown to the jury, but not the public. The government also respectfully requests that during the in-person voir dire process or the jury selection, photographs of the victim witnesses depicting their full names will be shown to prospective jurors, again, but not the public, to ensure that members of the jury do not know the victim witnesses. So yeah, that's another thing that could come up. I didn't think about that the jury, it's one thing to, they're going to have to go through a lot of questions. We saw that questionnaire, which we haven't touched yet on this channel. We will, but it's very detailed, very detailed. They want a lot of information. There's a lot of instructions. But on top of that, to even think that some of these potential jurors might know some of these victim witnesses.
Yeah.
And will they admit to it? If they do.
That's the question.
Now the jury's going to see pictures because they're not going to see them in person because of the anonymous factor of the jury. But yeah, that's the motion. 15 pages of it. So yeah, we're going to go live again with more of this R. Kelly stuff on Wednesday. R. Kelly Night Wednesday live every week is here, especially with this trial coming up. We've been trying to go back on that crime line. I promise you we're going to get current at some point. And, also just covering all these different things that are happening pre-trial. It's a lot happening, a lot. So,
yep. And more to come.
More to come. Very well stated. And I think we'll just end it here. So, as always, we appreciate you. Like, share, subscribe, comment. Let us know you stopped by. Let us know your thoughts on this motion from the government. Like I said earlier or yesterday's live, there's a lot of different motions probably going to come to light due to this new attorney and the fact that he only has a couple of weeks to prepare with I'm about to call him Mr. Kelly, with Sylvester. So if he's anything worth his salt in the legal realm, he's probably going to be filing motions, maybe trying to get rid of some of the charges. Maybe, I mean, we'll see. He has a deadline. So, as far as I'm concerned, it's kind of late in the game for all that, but, you can't really say. You gotta just
sleep.
Yeah, exactly. But yeah, I guess we'll end it here. And again, we'll be live again on Wednesday. Join us and we'll finish that up. But yeah, until next time. Oh yeah. Thank you. Thank you. Sending love. Peace.